A very good morning to one and all. At the outset, I, on behalf of JSS Law College Autonomous and NEETI Forum, welcome His Honorable Lordship, Mr. Justice K. Chandru, Professor K. S. Suresh, and Dr. S. Nataraju to this wonderful event. May I now request Professor K. S. Suresh, Chief Executive of JSS Law College Autonomous, to kindly deliver the welcome address and introduce the guest. Over to you, sir.
Honorable Justice K. Chandru and Dr. S. Nataraj, invitees, my dear students. JSS Law College, which was established in the year 1982, has been conducting various academic and co-curricular activities in the last almost more than 40 years. This NEETI Forum is a forum that was actually established a couple of years ago, where we would invite actually some of the legal luminaries to come and actually discuss or deliver talks on some of the current actually issues. Pranav Nair actually who's responsible for establishing this NEETI Forum. In the last 1.5 years, we have invited nearly a dozen the Supreme Court Chief Justices, judges, and judges of high courts and various actually other people. And most of them actually were online because of pandemic situation. So we have today with us a unique personality. Perhaps most of you know who he is. And we are fortunate to have him here, who has traveled all the way from actually Chennai to address our students. And he is none other than Justice Krishna Swami Chandru. And most of you know him because actually of his wonderful work in the field of law, which also has been actually brought on silver screen in the name of Jai Bhim. The real hero of Jai Bhim is Justice Chandru, and it is not our hero, Chocolate. Who has done actually so much for the ones actually who have been at the rock bottom of the social structure. Let me just actually give you a brief profile of Honorable Justice K. Chandru. Honorable Mr. Justice Krishna Swami Chandru, a former judge of Madras High Court, is well known for his simplicity, modesty, and speedy disposal of cases. He was born actually 8th May 1951 in Srirangam, Tamil Nadu. Completed his undergraduation from Loyola College and Madras Christian College. And at the same time, immediately after that, did his law in Chennai. And later on, he became a lawyer and worked in a firm called Roe and Reddy for 8 long years. And thereafter, in 1990, he was promoted as a senior advocate by the High Court of Tamil Nadu. As an advocate, he mastered in both the civil and the criminal fields of law. After parting from his job at Roe and Reddy, he joined Bar Association Politics of Tamil Nadu and was chosen as the executive member of Advocates Association. In 2006, Honorable Justice was elevated as an additional judge of Madras High Court and was appointed as permanent judge of Madras High Court by then President of India, Dr. APJ Abdul Kalam, in 2009. As a judge, he is best known for disposing of cases, 96,000 cases. Can't even imagine, I tell you. His short tenure, he could actually dispose of 96,000 cases, and most of them actually are very, very important ones. Some I would like to just actually quote here, especially the landmark judgments, where once providing support for 22,000 actually noon meal workers. Noon meal workers actually were not given any kind of a protection. His judgment actually gave them lives actually for those 22,000 actually noon meal workers, and also upheld the appointment of women priests actually in temples. You know, usually in temples, women cannot be the priests, but Honorable Justice actually the one who was responsible actually for appointing women as priests of temples, and also abolition of separate crematorium on the basis of caste. This is once again actually a kind of a heritage that you have inherited actually from the past society of India. Anyway, he could actually put an end to it. Caste basis cremation. And as a senior advocate, he is well known for winning pro bono cases related to custodial in 1993. That was actually one was made actually as a movie later on. And the same actually was made as a film in 2001 called Jai Bhim, and the real hero of Jai Bhim. And apart from this, his contribution to the society as a student activist lawyer, a judge. He is also known for his literary works, and he has authored a number of books and has written several columns in various journals. The notable literary works are Listen to My Case When Women Approach the Courts of Tamil Nadu. That's the title, right? Listen to My Case When Women Approach the Courts of Tamil Nadu. The second one, autobiography, I Too Became a Judge, and Jai Bhim, My Judgments in Light of Ambedkar. Throughout his career, he fought for the justice of several actually oppressed people and was extensively involved actually in the fight against caste discrimination in Tamil Nadu. And he retired actually on 8th March 2013. And post-retirement, he denied the office to head tribunals and various other posts. And he currently involved in social service. And he is with us this morning to address our students on the topic law and human rights. So I extend on behalf of JSS Law College a very warm welcome to Honorable Justice K. Chandru. It's my privilege that every student of this college wanted to listen to this lecture because nearly 700 students, but we cannot accommodate around 350 to 400 students we could actually accommodate. We are extremely sorry. The remaining students cannot actually come and be part of this wonderful program. And our invitation has been responded by various our friends. Dr. Chandrakant is here this morning. When he messaged me whether actually the lecture is today, I said yes and asked him to come. He's here. And my colleagues are here, and also the press is present. I extend all of you a very warm welcome to this program. Thank you very
much. Thank you, sir. May I now request our esteemed guest, Honorable Mr. Justice Chandru, to deliver his address.
Good morning to all of you. It's indeed a privilege to have been invited to your college and to speak on a topic which is of not only of current importance. Rule of law and human rights is something like which we have also been discussing 50 years ago in our law college. The same topic, only thing is a different set of students. Now, 50 years ago, what we would talk about the rule of law and human rights, and today you also speak on the same subject after 50 years. Now, what is the difference? Was there any difference at all? Is there any change in rule of law? Is there any growth of human rights? These are the fundamental questions you keep on asking, and there are no answers. In the last 50 years, after coming to Mysore, at least for the fourth time, I recall that what has happened in the last, say, 40 years. I could think of issues relating to Kaveri, water distribution, Veerappan case. You must have read Veerappan. Veerappan case also had its own side ramifications. Some of the tribals in the Amam Hills were ill-treated by the special task force, which led to human rights organization giving complaint to National Human Rights Commission, and National Human Rights Commission appointed Justice Sadasiva to inquire into the ill-treatment of the tribals in the Amam Hills area. The commission was initially stalled by court orders, and finally when the commission made several visits to Amam Hills and recorded statements of the tribals, you hear heart-rending stories that the tribal women subject to so many ill-treatment, including electrocution in the name of recording their statements by the SIT. Now, the commission recommended action against the police officers who are responsible, and also recommended compensation to be given to the women, the tribals who are also affected by the activities of the police. Now I know after the Jai Bhim film, many people of you think of the excluded communities like the tribals. what is shown in the film is the Yurula tribe. And then many people start asking, we are feeling very guilty that such people do exist in our society. There is also many mails I receive from the youngsters. Please tell us what we can do to them. Therefore, it is at least some point, it has started a debate on a people who have been so far excluded from the society. You know, 1/5 of the Indian community, Indian population has been kept away from any kind of development, any kind of governmental scheme, any kind of people's relationship. Now, when the Sadasiva Commission recommended compensation, it was not easy to get the compensation. There were several litigations that were filed both in Karnataka and Supreme Court, asking the court to issue directions. And therefore, when people ask me, is it something unique? The tribals have always received very harsh treatment at the hands of the state. The state, being a very violent machine, did not discriminate, did not show rule of law, and did show its ugly face to a people who can't defend themselves. Actually, the Sadasiva Commission report is available for reading. Most of you should read that why these people are subject to such tortures. Except that they were living in an area where Veerappan was holding sway. If you want to catch Veerappan, there are methods and methods by which you can catch. But then, in the name of catching somebody, you try to punish somebody else. This retribution has been there right from immemorial days. That is why you will find some of our text, some of the text which is prescribing good governance also says at the time of war, at the time of aggression, don't touch the children, don't touch the women, don't touch the cattle. But every time when there is aggression, it was these three groups which are subject to very much torture, very much the ill treatment at the hands of the armed forces. Therefore, when I look back last 50 years, what is the status of human rights and what is the level of index of rule of law? This is something which we'll have to ponder over, and I can only express some of my views. First thing is that a rule of law is opposed to rule of jungle. That's the first premises. I think there can't be any contradiction. When I say rule of jungle, it doesn't mean it's a derogatory term, because even in jungle, there are some norms. Even in this film, you will see the tribals who are catching rats at the instance of the landowners, at the instance of the agriculturists, they will never catch hold of the snakes. Whereas when we see the snake, we first meet the snake, we kill the snake. At the end of it, we also worship as Nagaraja, as Nagamma, or so many gods. So the basic approach to the common people, to the tribal people, they love more nature, they live in the nature, and their entire life is informed of preservation of nature, and we do the opposite. And then we call as civilized and call them as barbaric. This is the dichotomy that we have. So when I use rule of jungle, I do not use it in a derogatory sense, and I am sure that the jungle people have much better life and norms in which they live a better life. The question of law, when you talk about rule of law, who decides the law? Unless the law is good, ruling in terms of the law can never be good. And therefore, it is the law which decides the course of action for a better system. For example, if you see the American Constitution, which is more than 200 years old, it starts by saying all men are equal. Even today, you will be surprised, such an advanced nation like America has got a constitution where all men are equal. Why would all men? Then what about women? What about the blacks? It was not their intention in the beginning when they wrote the constitution that the blacks and the women will have equal rights along with the women. And therefore their intentions are very clear. 200 years before, it was only men who are equal. After 200 years, the constitution is not changed, but the content is changed. The society has changed. The women of America got voting rights somewhere in the 50s of the last century. The black were also eligible to get participate in the civic process. Racism was abolished, slave trade was abolished, and then the blacks were also brought into the main system. Therefore, what is written in writing, all men are equal, underwent a content change because the society got changed. The society lived up to its standard of bringing all sections free from discrimination. And therefore, when we talk about rule of law, who makes the law? That's more important. Secondly, who guides the law? Who shaped the law? It is a societal movement. It is a pressure group that make change. And we will see from the American example, the American Supreme Court had given many judgments, which we are also following in some of our decisions. And some decisions we have distinguished, saying that our society is different. We won't go into it because that itself is a different topic. But most important is that when you write a law and leave it like that to the society, society takes a long time to change. One day it will change because everything changes except the change itself is the well-known Marxist norm. Now, in America, take the case of education. Now, the blacks and the whites, there are two major races in America. They had different educations because of their own area in which they got settled. Each neighborhood is formed by a historical necessity. There are white only areas, there are black only areas, not by law, by convention, by practice. People started accumulating in particular area. Now, when this started of neighborhood schools, in America, the school systems are all managed by the neighborhood or the town committees. And this system of education, soon they found that there are white schools and there are black schools. It so happened, it was not intentional. People migrate to a particular area, get accumulated and start school, and then the schools are only white schools and black schools. Now some civil liberty champions, some lawyers, leading lawyers, they desire that this should be put an end to. If you have a black school and a white school, then there will be two Americas, the white America and a black America. Therefore, they appeal to the Supreme Court. American Supreme Court is very conservative. It is not known for a radical change on many issues. It's not a body which is a nominated body. And there is a process of nomination to the US Supreme Court. And the US Supreme Court and the American Congress and Senate has a considerable role in appointment. So they shape the American way of thinking. So the first time when a case was instituted by American Civil Liberties Union, they said that neighborhood schools should be multiracial. There can never be a racist schools. Now, American Supreme Court entertained for the first time a public interest litigation at the hands of the human rights champions. And then the outcome was very revolutionary. In 1965, the historic judgment in Brown versus Board of Education was rendered, where the American Supreme Court felt having neighborhood school slowly leading to color schools should become color blind. It should be a multiracial school, and there can never be a black only school and white only school. People knew when such changes come from court, there will be resistance. There were uniform resistance all over because the white people, the white parents said, our children will be affected if they go to black school. Similar sentiment was expressed from the black parents that if our black children go to white school, they will be mugged by the white children. So this natural apprehension reached the Supreme Court once again. And Supreme Court told the American president that you should implement this. The other argument that was brought in, that the schools were located in different places. If you want to have it multiracial, then the children will have to be taken from one end of the city to the other end of the city. How will they do it? The Supreme Court said, take the buses, run buses from one end to the other, and the children will be taken to different schools through buses. Sometimes this case is known as bus school row. Now, when this order was issued, the American president, who's a elected by the people, also reflected the sentiment of the people. He said it will be difficult to implement this order. And finally, the US Supreme Court, Warren, the US Supreme Court Chief Justice, issued a stern warning to the President of India, President of America. If you are not going to implement our order, we will call out the US Marines to implement our order. We will call the army. And then the law was slowly put into action. And you find from 65 to now, in a period of 57 years, that there is no color school in America. The children go to multiracial school. What they envisage, two Americas are only one America today. And the result was a Harvard law school educator, Obama, became president for 2 times. That is the effect of the 1965 Board of Education versus Brown case. How this initiative come from the highest court of America? Do you think all the time American court is so progressive? They are susceptible for all kinds of change, all kinds of initiative. I am for one who believes that the structural change can never come from court. And if you see the American judiciary's composition, there are 9 judges who sit together and decide all matters. So it's always 9. The 9 is always not unanimous. It's always majority of the 9. So it is always 5:4. The 5:4 can also become 4:5. Normally, the American Supreme Court does an experiment of changing laws, like changing shirts. It takes some time. There are a lot of lobbying. The law school do play a role. The law professors do play a role. They keep on writing law journals about various issues, about critical remarks on the various opinions issued by the Supreme Court, and therefore the change comes slowly. Now this 9:5, which the Custodial calls it as a number game. We do have a number game, but we don't sit as a number 9. All the Supreme Court judges in India do not sit together. All the 34 never sat. At the maximum, we had 13. Kesavananda Bharati's case. Kesavananda Bharati's case, comprising of 13 judges, was not a unanimous opinion. It was only an opinion divided between 6 and 6. And the swing vote, the opinion which was changed by Justice H.R. Khanna, who's known to be one of the finest judges in Indian judiciary, he introduced the rider to the majority opinion that you can change every provision of the Constitution, including the fundamental rights chapter of the Constitution, but you cannot alter the basic structure of the Constitution. So the basic structure of the Constitution was a theory which was pushed in and brought in by a swing vote, and therefore the opinion was 7:6. And then we have Kesavananda Bharati, which became a landmark that a fundamental right can be altered, but never the basic structure. The question was, what is basic structure? That is going to be again a lawyer's paradise, because we will be litigating what is basic structure. Supreme Court merely indicated that it is a democratically elected government, preamble to the Constitution, judicial review under 226 and 32. They only gave some examples, but they never made what is basic structure. If everything is said by the Supreme Court, there is no role for lawyers. Therefore, we can still have play on it. What is basic structure? But this swing vote in America, 4:5 and 5:4. Recently, you will find the last 1 week, there are raging controversy. American Supreme Court in the early 20s, in the start of the new millennium, issued an order that abortion is legal. The abortion issue is one of the heated topics in America, though not much in our country. We have a very advanced law in India, though we have a backward looking people, but the laws are very advanced in terms of abortion. But in America, each state has got its own debate whether abortion should be legalized or not. That also has certain bearing on religious overtones. America being a Christian nation, and the theory of life and creation play a dominant role. And therefore, there are activists, there are lobbyists who argue pro-life and anti-life. If you are a supporter of abortion, you are anti-life. If you are a supporter of, if you are opposing abortion, you are pro-life. Now this pro-life, anti-life demand, this demand keeps going to the extent in the early beginning of this century, the American Supreme Court in Roe versus Wood ruled by a majority that abortion is legal. Now, why you may ask me why you are asking this, posing this question. Now, after 20 years, there is now going to be a shift on this judgment. Now, the American Supreme Court is going to pronounce immediately after the reopening of the court that Roe versus Wade was wrongly decided. Abortion cannot be legal in this country. Now, this shift from a progressive standpoint to a very regressive standpoint is a shift in the American thinking. Though we do not have direct bearing on this, but one bearing is that it is not judges who run this country. There is a famous saying, the Constitution is not what is written in the Constitution, it is what the judges say. If that is true, then this judgment, which is going to be pronounced, can have a regressive thinking on a very top court in the world. What is most important is the judgment to be delivered in our country, it will be kept in a sealed cover. Only on that day, the court master will open and the judges will read. But the American Supreme Court judgment, what is to be pronounced is already in the Google. If anybody wants, can Google and read what is going to be judgment. Who leaked it to the press? What will be the impact of the leak? We do not know, but the judgment is available. Now, why do you read about America? Because there are many issues where we need to also follow the precedents laid by some other democratically elected country. It is in that sense that in our country, the court play a very important role. And rule of law, when you talk about, it is a rule of law what is dictated by the court. Very humorously, once Krishna here said, is there one court in this country? There is one building called Supreme Court in Tilak Marg, but within that court, there are 34 Supreme Court. That means each judge can decide by himself. And fortunately, the court does not sit in single, it sits in benches. But then the benches are constituted by the Chief Justice of India being the master of the role. And therefore, the opinions are also sometimes shaped. Sometimes it can be this way or that way. Many times the decisions are taken together. And then the author of the judgment is also mentioned. He is the author, and we agree with all this. Now, there is one significant judgment which came last year, 2 years back. It did not contain the author. It contained the signature of all 7 judges. Who wrote the order? Nobody knows. Maybe we can go deconstruct the language and find out who might have written this. That's a speculative game which most of the journalists now play. This man must have written this because this word is there. It's also not very difficult to find out. So very humorously, it's called unanimous but anonymous judgment. Now there are other judgments, like you take the case of Ayyappan, whether women can be a worshipper, whether women can visit. A 4:1 judgment is there before you, given 3 years back, not implemented till date because it's a review pending. And there is always this 5 will have to be reviewed by 7. Then somebody said there is a 9-judge bench. Why not we are separate to a 9-judge bench so that the previous judgment in the UP case can be considered? So it's before a 9-judge. When these 9 judges will meet is another question. Because a very crucial issue, whether it is a special status for Jammu and Kashmir or Citizenship Amendment Act or Ayyappan matter, everything is before larger bench. When the larger bench will meet, we do not know. But then as and when it meets, as and when decisions are rendered, then that becomes the rule of law of this country. Because you do not have any other court above. They are supreme, not because they are supreme, because it is final, it is supreme. And therefore we have a Supreme Court judgment. Now, when we talk about rule of law, as I start coming back to the original topic, the law is decided normally by the parliament and later by interpretive process, the court also steps in. There is always a danger. Is a court is a third chamber? Is a court is another parliament? There is always a discussion whether the parliament or the Supreme Court, whether they go into one area which is completely marked for the other area. The division of territories is also decided by the Supreme Court, and therefore you have to function within the areas assigned to you. The Montesquieu doctrine says that you cannot go step into other areas. To step into other areas, what happens? Then it may be called as the cross-border terrorism. Because the area is meant for them, and you are not lawmakers, you are only interpreter of law. The lawmakers are elsewhere. But there are occasions where the court steps in and makes a law. Like you take the case of sexual harassment case, Vishaka's case, where Supreme Court laid down the law in 1999 and then said it is open to the parliament to make a law. And parliament did make a law after 16 years in 2013. So there are sometimes, occasionally, the courts make their own law, even though they don't say they don't make law. By interpreting a provision of the law, they also do contribute to the growth of law. So it is in that sense, when you talk about rule of law, you also talk about the law as made by the parliament and as interpreted by the court. This becomes a law. Now the rule of law, once well established, the question is, we turn to human rights. Now human rights is another issue where we tend to again keep on investigating what is a human right, which is the repository of the human rights, what is the power of the court to step into the area where human rights can be expanded. I know there was a time when the pre-detention rights of the accused were not well defined. Though we have a very important article, Article 22(1), which gives what is the right of a pre-trial accused. 24 hours production before magistrate, the lawyer of own choice, and inform of the grounds of arrest. Now these three principles constitute our fundamental right under 22(1). Everybody knew, but what really happens in theory is very clear. But in practice, what happens? Do they really follow all these criteria? Somebody asked me, after this film came, do you think things have improved? This case was argued in 1993. There was a custodial torture in the police station. The grounds were not mentioned, not produced before a magistrate. Lawyer own choice was never given. He was killed in this lockup itself. Now the lawyer of own choice, you come to the constitutional. What is the choice? Can I engage Ram Jethmalani? Can I engage Sorabji? Can I engage some top lawyers? Even if you give me the opportunity, the economic conditions of this country do not give you that kind of sustenance by which you can have a choice of the lawyer. Why choice of the lawyer? I can never have any choice. I'm just condemned. And then produced before the magistrate. There are magistrate, before remand order is passed, the magistrate has got certain duty to perform. You must have heard of the case in Satanguram, where a father and son were murdered by the police in the lockup. The father and son, after being tortured, having visible injury mark, having blood stains all over the body, to produce. What is the role of a remand magistrate? The remand magistrate has to see where you ill-treated by the police. On question he has to fill up. On the remand report, he has to write. The accused produced no visible injury mark, did not complain, was not required to have any medical assistance. They were offered to have the assistance of a lawyer, not secured. I consider the fit case for remand. All that was done by the judge sitting in the first floor of his office. When the father and son were kept outside the gate in a hired taxi, they were there. And never the magistrate had the duty conscious to go and see what is the condition of the accused. He mechanically said, remand them to some sub-jail in Koilpatti, some 100 kilometers away. 100 kilometers away, the father and son were taken and died in the jail itself. Now, these two they are traders in the town. They belong to a dominant community in that area. The news of their death was internationally reported. Even New York Times carried a news on this incident. When such huge publicity, such visible campaign is there, the government immediately ordered a CBI inquiry. Nobody asked. They knew the situation is worse because there were several injuries on that person. Nobody can explain. And now CBI is conducting inquiry, Madras High Court is monitoring, and they have given a direction by November, you must complete the trial and give the sentence. Now case is going on a fast track. In 2 years, a case can be over. You see in America, a similar incident, a black was killed by the road cops. Floyd case you must have read in papers. The Floyd case, which happened in a public place, the trial was over before the trial court. The appeal before the state Supreme Court was completed. The special petition by the accused before the US Supreme Court is completed. The compensation is given. The cops are in jail, all within a period of 1.5 years. Now, therefore, to have law is not enough. You must have a working law. You must have a dynamic law. You must have a system by which the law can be more organically enforced. That you saw in even to some extent in Sathakulam case. After the Sathakulam case, I wrote a letter to the Chief Justice saying that why is this magistrate no action is taken? He is the culprit. He did not send them to the hospital. He did not even physically see them. Is it not a constitutional right? In 1993, we did not have the D.K. Basu was a West Bengal case that came much later. D.K. Basu was a judge of the Calcutta High Court. He petitioned the Supreme Court saying that Article 22(1) is not been explained. So the Supreme Court had the time and energy to expand the pre-trial accused rights, and the 11 commandments were incorporated in D.K. Basu's case. So in Sathakulam case, there are 11 commandments of the Supreme Court, where the Supreme Court also said, if any of the magistrates do not obey this, action will be initiated against them. Now the Sathakulam judicial magistrate was left out. I wrote to the Chief Justice, why we are not taking action? Is he immune from any action? If at the trial stage, if the judicial magistrate is not going to have a check, there is no safety, there is no protection from the torture and the ill treatment by the police who are investigating the case. Now, the human rights standards are not merely laying down standard, he is to implement that standard. Therefore, when you talk about rule of law, it is that rule of law we are talking about. A rule of law which can catch the imagination of the people. A rule of law which will be made the lowest level of the judiciary to start working within the constitutional norms. It is also will make the higher judiciary to be more responsible to people's need. They will inquire matters. You take in Jaibin case, in 1 year, the habeas corpus is over. But it took 13 years for the murder trial to go on. It took 3 years for the murder appeal to be heard by the High Court. So to punish an accused in this country, it takes 17 years. Now, do you call this film may have made a very great impact, but it did not have an impact in terms of the judicial working, because everybody should have their own contribution to the rule of law. Unless the rule of law will remain only a mirage, the human rights only will be paper, and the Sathakulam magistrate escaped. No action. He lives in the first floor, and the police van and the police taxi waits outside, and then papers are sent to him, and he writes no complaint. Who should make a complaint when you are sitting in the first floor? This is where we'll have to start thinking. In our country, we have enough laws. In our country, we have enough judgment, but we do not have enough people to implement all these things. Today, many people make glory about encounters. Many people talk about encounter as an instant justice. Now, instant justice is very parallel. Like even last week, the Chief Justice of India said that the curse of this country, people are instant noodles and instant coffees. They want instant justice also. This is what they say. But what is important today is that when the criminal administration system fails, then people look for instant justice. People look for mafia role in this country. Every police station has become a kangaroo court where the police decide. This is what Patal, if you see in the film, the first scene you will see, the tribals were brought out from the jail. There are policemen waiting to take them back to the jail. Why? Because they are all criminal tribes. Is there anything called criminal tribes in this country? There was a Criminal Tribes Act during the British reign. where certain tribes were made as a criminal tribe. According to them, by blood, they are bound to commit all these crimes, and therefore they should be noted. That was not the reason. When the British came to this country, they did not have enough armed forces. They did not have enough army to control this huge nation. So they set up a police force. For what? To maintain law and order. The crime was not their concern. The crime direction was not their concern. For them, every mob was to put their place so that their rule continues, their profit making continues, their settling this country can continue. And therefore, the police force was established. And then how did the crime direction come in? You make some community as a whole criminals, criminal tribe. If your community name is added in the schedule to the act, then you are a criminal tribe. Then what do? Every eligible male of the tribe will have to give their fingerprint to the police station where you are living. And as soon as there is any crime in that area, there is a tom-tom. All the male surrender. If the persons who do not surrender, they are deemed to be the criminal. What punishment? Whatever punishment the circle inspector can give, can give. The police station became judiciary. The inspectors became judges. And whole lot of tribes were condemned. The Congress party, the Communist party were demanding repeal of this law. Because nowhere in the world that you have a whole lot of tribes are criminals. Never, even anthropology, even sociology, even a highest form of science, never made a whole tribe as a criminal. And then British made. Still they were claiming champions of civilization. Still they were claimed as the greatest human resources the world has brought. And now when there is a demand for repeal, it did not take place during the colonial rule. It was the independent India which repealed. Then what is the name of this tribe? DNT, denotified tribe. Today they are called denotified tribe because their names are taken out. Now their names may be taken out from the schedule to the act. Act may be repealed, but the policeman's mind is not clean. The policeman still believe that any crime in this area means it could be done only by these people. That is how in this case, Raja Kannu was booked. Not because he was a thief, not because he has stolen it, because he belonged to a criminal tribe, which is no longer a tribe. Then they only said, only one family in that village, and they were made as an accused and tortured so that he will agree to the crime. And he did not agree and he went to death. That's a different issue. What I'm saying, how do you change the mindset? You repeal the law, you make some rehabilitation schemes, but then the mindset of the cops, mindset of the uniform forces never changes. We are giving a lecture in Hyderabad in the police academy for the IPS officers. Every big officer we are lecturing about sensitization. But what about the down the level? The mind is still there. In fact, there was a case in Madras. Every accused will have a prefix KR. KR means Korava. IR means Irula. So the charge sheet will contain Kumar, Raja Kannu, KR, Korava. We told the court, how is that you are giving title to every accused? The High Court issued an order saying that no prefix will be there. Recently, a judge from Coimbatore sent me a document where even the court record, when they record witness statement, they also write caste name of the accused. How is it relevant? How is the caste name is relevant? Even today they write. So the judge asked me, sir, should I write the name? I said, don't write. Then tomorrow they will take action. I said, no action will be taken. If they take action, it will come to public and we will see. But what I'm saying is our mindset has been set in a framework which is 200 years old. Our crime detection method is again old, go back to square one. And then we'll have more Raja Kannus, we'll have to keep on that. It's not one Raja Kannu, 23. Even in Madras, last 4 weeks, there are 5 police station deaths. Instead of going down, it is on the increase. They may give compensation, they may order CBC inquiry, they may also have a fast track trial, but the life is not going to come back. And therefore, when you talk about the rule of law, when you talk about human rights, where does the protection for human rights start? Writing enough laws, set up judiciary with good papers, good recruitment process, all that is over. But where is the implementation? So between the theory and practice, we have a huge gap. The difference between our country and other country is this, that you have law for everything. You have judiciary to look back. But when it comes to implementation process, it's totally lacking. And we do not know when such people will get justice. This is one issue. Second issue is that things are being decided not by the rule-making authority, but by people who are outside the rule-making authority. We have several instances. Take the case of age fixation. Now, under the Juvenile Justice Act, a child is a person who has not completed 18 years. Once you are a juvenile, you are tried separately. Because the feeling is that at that age, the mind cannot be crime prone, and therefore it should be treated and brought to the mainstream life. Now 18 is now reduced to 16. Why? If you see the JJ Act of 2000, it starts by saying it is based upon the Beijing Convention and the UN resolution. Now what happened to the international standard? What happened to the international convention? Now how is it 16? Because when the Nirbhaya case took place, of all the accused, there was one accused was below 18. He has to be tried only under the JT Act. I was there when the trial was going on in Saket. Everybody was shouting, hang all the accused. I said, one accused cannot be hanging because he is covered by JJ Act. They said, hang the JJ Act also. I told one protesting women volunteer, that's not possible. He has to be tried in some other forum where there is no death sentence. Then change the law, sir. I said, even if you change the law, it will not apply to this case because you can't make a retrospective law in criminal law. It has to be only prospective. We don't understand your law. They petitioned to the Supreme Court. They petitioned to the commission headed by Kuldeep Singh. And finally, Kuldeep Singh commission did not recommend reduction of the age. But then they knew Parliament more responsive. So the Parliament suddenly brought it to 18 to 16. Now 18 to 16, even juvenile can be tried along with others. Now there is a change. Now you take another case. The voting age was 21. During Rajiv Gandhi period, it was brought to 18. There was resistance that you are even making school students, college students, political by giving the voting right. He did not mind because that was the international convention that 18 is a majority and therefore constitution was amended. You today vote, go and vote for whoever you want. You vote or you don't vote or you put nota, whatever it is. But there is a right to vote, right to select your own representative who will make a rule on you. Now that is reduced. Now then you will find a new change. Marriage age from 18 to 21. Now are we not playing a game on the age of age? 18 to 16, then 21 to 18, now 18 to 21. What is the logic? Now I am on the last question that if you make the marriageable age to 31, there are two strong groups which are saying that one is the women will be more mature. I think why? What is this maturity that you are talking about? We started with 11. The Hindu law, the original marriageable age at the time, even before it was codified by convention, it was at the age of 11 we are getting married. People were struggling to bring it to 15. And finally, when it was reduced to 18, there was a lot of resistance. Child marriage was rampant in this country. But to make the people to think that we should have not child marriage, it was agreed. Now from 18 to 21, what is the logic? Can anybody tell you? Did we ever discuss this? Now there are some people who supply reasons. What is the supplication? And the reason is that at least the girls will go to college and study. That's a different issue. You cannot have a oblique motive for a law. Now the point what I am now emphasizing, which I also had experience sitting in court. We have a Madurai bench. Once in a year we let go 3 months there. There are a number of habeas corpus comes in. Habeas corpus, as you know, is not only against the police, even anybody who detains you, even against a private person you can file. So every day we'll have 10 cases where a girl runs with a boy from the village. Then the girl's mother, father, uncle files a case saying, bring the girl. So we bring the girl to the police, and then the habeas corpus bench, she is produced. We ask that girl, what is your age? She says 17 and half, +2. Now we do not know what to do. There was a time in Madras High Court, we sent the girl, because she was a minor in law, we sent the girl with the parents, right in front of the court, in the NSC Bose Road, Netaji Subhash Chandra Bose Road, in which our High Court is there. She was murdered in front of the court by the very same parent. So we have an honor killing. What is a big honor in this? The caste purity. What is the caste purity? Nobody knew. That has been deep in your mind. Therefore, sitting in Madurai, we never sent any girl along with the parents. We remembered of the Mother Madras incident, and we never sent. But then, how to keep the minor? We can't send them to the vigilance home, which are very bad, poorly maintained by government. So we asked some lawyers, why don't we keep this girl for 6 months? We asked some NGOs, keep this girl for 6 months, and then bring him back. By the time against the husband, kidnapping case is filed. And then this girl is brought back. We ask her opinion, you want to go with the father? You want to go with her husband? She says sometimes, I swear that way. That is different. We have nicknamed these habeas corpus as lovebird cases. Now, what used to be 5 cases, now there are 10 cases every day. We do not know what exactly to be done. That is why I continue to say that the judiciary can never change the structure. Judiciary can never find answers to this problem. It is a village instability. It's a village which is refusing to protect these people who want to get married. It's a village which operates on a caste system, which is a village which questions the intercaste marriage, which is responsible for this kind of thing. And all that we could find to get the girl become major, get her opinion recorded, sent out. We are only disposing of petition, not the problem. That is the most important question that I want to pose. That you write law to make it 21. The day when they announced this, I was thinking what is going to happen to our lovebird cases, because 21 is the extraordinary age which we can't do. Now, when politicians, without reference to people's aspirations, without reference to people's wishes and wants, start dictating on the question of age, this way, that way, or they all have magic band, do we not have a say in the matter? As law students, as lawyers, as future judges, do we not have a say? Do we not have a discussion on this point? To set a standard, how much is going to have an impact? Who dictates your dress? Who dictates your food? Who dictates your prayer? Whether you should eat halal, whether you should wear hijab, whether there should be azan, call for prayer. Somebody says, now what is important today, the point I want to drive, beyond the established agency which is to maintain law and order, we have private groups which start deciding the rights of partners. This is the extra constitutional authority which is mushrooming, which also dictates. Yesterday a criminal case was filed against JBM producers. For what reason? It is bringing difference of opinion between 2 communities. All newspapers are carrying that. The film has come 6 months back, ran for hundreds of shows in OTT platform. But some group says, oh no, you are offending our community. No community is offended. But what the Supreme Court has said in the judgment in Rangarajan versus State of Jagajeevan Ram, that once a film is certified by the Film Censor Board, no state government can ban that film. What about law and order? Even then Supreme Court said, if there is going to be a film certified by the censor board, if there is going to be a law and order, the police must give full protection to the movie house and not protect the asylums. Now, how do you explain that some group can start an issue which is a non-issue into an issue, and then make it to a level of an all India attraction? Today, thanks to media coverage, every possible thing that has been put in the public. Every place is made as a usage of a place where every experiment is being carried. What about the cherished principles underlying in the Constitution? The Constitution talks about right to have a faith of one's own choice. The choice can't be dictated by anybody. The choice is left to me. Not only choice to follow, choice to preach. Whatever I believe, I can preach. Constitution gives a guarantee. Now, what do you find? No, you must have a registration. You must have anti-conversion law. How do you make law contrary to the constitutional principle? Now, can there be a law? I must go to an officer, special officer, tell him from A religion to a B religion. Am I not registering my mind, not my body? The same Criminal Tribes Act only registers the fingerprint. Today, your thinking process has to be registered with an officer. How do you explain this? Are we still going into a progressive, a civilized world full of law, which is commensurate with the civilized standard which has been set by the world in civilized society, or we are going backwards? Whether it's the case of food, whether it's the case of language, whether it's the case of shelter, everything there is a problem. Now, as lawyers, or the future lawyers, or people who are going to be trained as a lawyers, what is our role in all these things? Do you just passively see this, or make it as a moot court competition, or we actively participate in this organic process of decision making? Do you have a say? In 1975, when emergency was declared, hundreds of people were detained. Prime Minister Modi was in jail for 21 months. Advani was in jail. Vajpayee was in jail. Is not anybody to protest? We lawyers, we protested. It's not enough to learn constitution, but also to see that the constitution being implemented in all aspects. Therefore, as law students, we have a greater role to play to understand the law, to make the law much better than what it is, and to see that the law is implemented in letter and spirit. Then you will have rule of law. Then you can defend human rights. Today, why should it be left to one individual, one lawyer, Chandru, as a protagonist? He will defend everything. It's not enough. Every bar room, every bar association, every advocates association should have a human rights. I find there is a total abdication of the role of the lawyers because they are only interested in making money. Like a jukebox, you put money, it will also have a song of your choice. That is not the role of a lawyer. The role of lawyer is beyond. It is to defend the Constitution. It is to defend the implementation of the Constitution under all respect, at all cost. The consequences are immaterial because I am wedded to law, I am wedded to rule of law, and the rule of law, the mother law, is the Constitution. And I will not allow anybody to tinker or tamper with this Constitution. If you see the 72 years of this subcontinent, Pakistan has failed, Bangladesh has failed, Sri Lanka is in doldrums, Nepal is yet to create a new constitution, but we still have a constitution. 72 years, proudly we are having a constitution. Of course, there are amendments. It is not a holy book. It's not a scripture. We have had 102 amendments. Every amendment is being discussed. Now, with all this, there is one thing which is lacking. On the day when this constitution became final, on 26 November 1949, Baba Sahib Ambedkar made a very historic speech in the Constituent Assembly. It is there available in the website, you can go and see. One of the brilliant speech. He said, our task is done. This draft is before you. It is for you to adopt this draft or not. But I will tell you one thing, that today we have a political freedom. We are yet to achieve social and economic freedom in this country. Until such freedoms are achieved, this country can never be a democracy. It will collapse. Now, this is the speech he has made. And therefore, it is our job to carry forward the message issued by Dr. Ambedkar, who said that the political freedom can be there, but economic and social freedom, that has to be sustained in this country. And that role is left to the lawyers, or at least the future lawyers like you. Finally, I will tell you one thing. When this film came, the female role of Sangeni was brilliantly portrayed by Lijomol Jose, a Kerala actress. And there was an award function last month in Chennai. Some magazine gave an award. They asked me to give the award. After the award was given, they told me to say a few words. I said, Lijomol Jose being given a lead actress role is nothing new, and she has played a brilliant role. And if Lijomol Jose come to your house, you will welcome her through the front door, put her in a sofa, give her coffee. When the real Sangeni comes, will you open your rear door? Between the film, between the real and real, the life is different. The day will come when the real Sangenis are welcomed by you. That day, the tribals will become part of the inclusive society and will not face any discrimination. And there need not be any slogan like Jai Bhim, Jai Bhim.
Thank you, sir. It was indeed very informative and empowering. I now request Ms. Neha Jagdish, Assistant Professor, JSS Law College Autonomous, to present a token of gratitude to our esteemed guest, Justice K. Chandru. I request Ms. Naveshri, coordinator of this event, to present a memento to our beloved Chief Executive, Professor K.S. Suresh. I request Ms. Chandana, the coordinator of the NEETI talks, to present a memento to our beloved principal, Dr. S. Nataraj. May I now request our principal, Dr. S. Nataraju, to propose the vote of thanks.
Good morning, everybody. Respected dignitaries of the dais, members of the teaching and non-teaching staff, dear students, and all other invitees. Before concluding this program, I consider it a privilege to express vote of thanks to everyone. At the outset, I express our gratitude to the esteemed guest and the resource person, Honorable Justice Shri K. Chandru, former Judge of High Court of Madras, who is kind enough to accept our invitation, and he has enlightened us by delivering the talk on rule of law and human rights, one of the basic features of the Indian Constitution. Sir, your speech is really informative and inspiring. On behalf of our college, NEETI Forum, I extend a heartfelt thanks to you, sir. I also thank our Chief Executive, Professor K. Suresh, who is always guiding us in all other academic and other activities. And he has presided over this program. I extend a sincere thanks to you, sir. I sincerely thank all our faculty members, students, volunteers, and the coordinators of this program, especially Mr. Pranav Nair and Ms. Neha Jagdish, were instrumental in organizing this program. I also thank all the students, especially the media person and the invitees, and we have guests from other the institutions, Dr. Benjamin, Mr. Kantraj, and other guests, and all others who are present here. Thank you very much.
Okay, we have come to the end of the formal meeting. Now the forum is open for discussion. If anybody is having any queries or questions, you're free to discuss the same with the chief guest. Now I request Jhalak Darla to take over.
Good morning, everybody. I'm Jhalak Darla, and I'll be putting forth the questions which you all have given to sir. So the first question being, with the current legal environment being so dynamic, how should the budding lawyers perform to cope up? Repeat the question.
I am not very competent to give you that way. I can only tell you one thing. I always tell this to every bar meeting, every lawyer's meeting, that this profession do not require a body which is a six-pack body. It is 6.5 ounce bright as we can show. During the available opportunity, you must be able to master the nuances of law, the logic of law, the presentation. And once you are able to keep that in mind, you must be able to use that for good work. Corporate lawyering is always there. There are corporate houses like group people during campus interviews. But I find after the firm, several people are interested in coming to litigation area. There is still scope for litigation because thousands and thousands of poor people in this country do not get their rights realized through court of law. And therefore, your help with your knowledge and skill, if it goes to the benefit of this kind of people, certainly your life ambition can be fulfilled. Whether your copper will be fulfilled or not, that's a different issue. But you have a nice mission that what I got it, I will give it to someone. In that sense, the period in which you are in law, shape yourself, keep yourself, sharpen yourself, and then try to use that strategy for a larger relief of the people.
Usually, judges agree to become arbitrators or mediators post-retirement. But sir, you have not taken up any such positions. Can we know the reason behind it?
We have two types of judges. One is a forward-looking judge, other is a looking forward. Even while they are in service, they look for something. Whether I become a governor, whether I become a nominated MP of Parliament, whether I be made as the vice president, whether I be given some other something which even the statement made by Arun Jaitley in the Parliament, saying that this is nothing but corruption. Because while you are in this post, you are looking for something else that should be avoided. To the extent possible, that people like Krishna, please never accepted any comment on it. And we continue to follow and consider. And of course, you can't change the whole world. Change that. Once you have fulfilled your life as a job, you should just build an article.
So with that, related to that, do you think 65 years of age is too early for a Supreme Court judge to retire?
American Supreme Court, it's a light term. American Supreme Court, it's a light term. Only when the judge wants, he will retire. Recently, one woman judge retired because she said, I want to take care of my husband who is having cancer. So at the age of 80, she is putting her papers. But in our country, we are having fixed term. Originally it was 60, for the High Court, it became 62. Then for Supreme Court, it is now 65. Our Chief Justice of India recently said 65 is a very young age, it has to be increased. So he wrote in a magazine, Justice Ramana, it will be done after your retirement. Sometimes retirement is the only way out for getting rid of several people because otherwise they may continue forever. And then what good work they do, we do not know. Now, in respect of High Court and Supreme Court, several new tribunals have come. So it's not 65 in way. There are many tribunals in 71. 5 years extension they get. So I think they self-perpetuate their existence by being in several places. Of course, Bogai did not go that way. He went through a political program, became a nominated member of the Rajya Sabha. One good thing he did, he has published a book. The title of the book is very interesting. Justice for the Judge. Can you ever think the Supreme Court Chief Justice saying justice for the judge? Now, as if it was lacking for him, in fact, it was given more for him. So when he released the book in Delhi, he wanted to have image building. He wanted some good judges to come and receive so that media, also in electronic media. So one day he called me, sir, will you come to Delhi to receive my first copy? I never want to go anywhere. I said, I'm not coming to Delhi. I buy in some bookshop at 3 o'clock. But what is important was after the book reading, one TV person asked him one question, is most important. Justice Gowai, can you deny there is no corruption in the judiciary? The question book reading. He said, I can't deny. So it is something like a confession statement that you find from the highest order that there is no judiciary, higher judiciary can't be. So that becomes a worrisome because we expect at that level there will be no corruption. But on the contrary, the man who held the post saying there is, I cannot contradict, he said. And therefore, what is worrying is this corruption. Now, corruption, according to me, is not only taking cash for orders. Corruption is not deciding case also corruption. If you want to get some relief, and I don't give the relief,